I believe we have 2 that can't attend.
Okay.
Yes,
You were coming across Maria as Dave Anderson, and I did see it once or twice, and I kind of like opened it, looked at it, looked like some, somebody sending me some webinar thing that I had no interest in, so I just skipped over it.
Yeah, no, apparently, when they created the account, it was created with him. And they just gave it to me and they couldn't change the name for some reason. So yeah, a lot of people say that it comes up in his name still.
Yeah, yeah.
I don't know why my camera won't work.
Hmm. So what is the latest forecast for tomorrow? I've heard various reports, but my wife told me 8 to 12 inches along the coast. I mean, you're on the coast, we're on the coast.
Yeah, it was 3 to 6 yesterday when I went to bed, and now it's like it was 6 to 8, I think, this morning.
Hmm.
The latest I heard was 7 to 11.
It's going
Yeah,
up.
that's what I heard this morning was, we were not going to be spared like we were yesterday.
we'll wake up tomorrow. It'll be 3 inches.
I hope so.
It seems lately the snowstorms are too wet for the snowblower. That's not good.
Hmm.
I think we have everybody, right?
Hi, I'm joining without video currently because I'm in the car, but hi Pete, hi Ira, thanks for coming.
Hi,
It's
Aaron. How are you?
Good, how are you?
Good.
Well, if we have everybody,
Should we get started?
sure.
Yeah. Do we need to open this as a meeting? I guess.
Yeah, it's a public meeting, right?
Okay. Well, I'd like to open up the special meeting for the Inland Wetlands and Watercourses Agency at 6:03 p.m. on February 12th, 2024. And we have in attendance from the agency, myself, Tom Clancy, Joe Goudreau, and Anna Loss. And then we have our town council, Ira Bloom and Peter Gelderman, and of course, Maria Patello and Aaron Hennigs.
Okay. Should I start this?
Sure.
Yeah.
Okay. Well, good evening, everybody, members of the agency, and I'm Ira Bloom with Pete Gelderman from Bertram Moses. So we're happy to do this orientation session, and we're going to go through a lot of topics and kind of split up the outline that you received last week, and save time for questions. probably best if we just try to get through it all and then take the questions, as opposed to, just, interrupting with questions. So maybe it's best if we just try to get through the material, but it won't take that long. Probably can do it all in, half hour or 40 minutes or something like that, and then leave plenty of time for questions, would be my guess. So we're here to talk about, wetlands issues. And I'll start off with a couple of quick topics, and then I'm going to hand it over to Pete to talk about some of the timelines involved. And then I may cover other topics such as bias or predetermination and conflicts, and those important issues. And then Pete's going to get really, I guess, maybe to the substance of it, perhaps, what you do as a wetlands agency and some of the parameters for looking at a particular activity and a particular application. So just briefly, I'm going to talk about notice. There's a paragraph in the outline, and notice is often left to the staff. So Maria and Aaron would normally be the ones looking at notice, and usually agency members don't have to worry about it too much, but just as some indication of how important notice is, and how it can get a little more confusing nowadays. I mean, today was a good example because I had a couple of calls from different towns about meetings that were scheduled for tomorrow night. And for those of you watching on tape, on video, we're expecting a major snowstorm starting tonight into tomorrow. So some meetings might be canceled tomorrow, and this is too late to have an all Zoom meeting. And what about a hybrid meeting? And if it was scheduled, it was noticed as hybrid, how do we switch it, et cetera? Those are all kinds of notice questions, which are a little beyond the scope of what we're going to do tonight, I think. But that remains a critical topic, getting the notice right. And then, of course, the substance of the notice is also important, to make sure that you describe the applications in a manner which reasonably apprises a member of the public as to what the topic is. That's kind of the standard. So somebody looking at the notice can say, okay, I see what that is. I understand basically what that is. I can get more information somewhere, at town hall, maybe on the website, but I know what the topic is. And if they can say that, it's probably good notice. If they can't say it because it's just not clear, then it could be inadequate. Goes without saying that if somebody cannot participate at a particular meeting, they should notify the chair. They should notify Maria and or Aaron, so that people know you're not there, and an alternate perhaps can be seated in your place. Let's go to the time requirements, Pete, if you want to talk about that. They differ a little bit in the wetland situation from a regular planning and zoning commission. So it's important, I think, that we cover this here for a few minutes.
Sure. Thanks, Ira. I'll go out of order a little bit here. It'll make more sense. Obviously, I think the commission knows that it generally does not hold a public hearing when there's an application. There's three circumstances, and there are only three circumstances when the commission should hold a public hearing. And those are outlined here. It's basically if the the agency determines that the proposed activity may have a significant impact on wetlands or watercourses, or if there's a petition filed by 25 people who are 18 and live in Madison, or if the agency determines that it's in the public interest to hold a public hearing. In the absence of one of those three things, there should not be a public hearing. You should make decisions, without such a public hearing. And with respect to the may have a significant impact, the key is that typically what you have is when an application is filed, and by the way, these timelines I'll talk about in a second, apply the 65-day part will apply whether there's a public hearing or not, at least for the for the commencement of the hearing. So if there is a hearing, so there's an application filed, there's generally some material filed with that application. There may be a meeting that you'll hold to review that preliminarily and make a decision if you're going to hold a public hearing or not. Now, the reason you hold a public hearing is significant, because if you hold a public hearing because an activity may have a significant impact on wetlands or watercourses, then generally you're going to be getting into a situation where an applicant needs to consider feasible and prudent alternatives. If an application or if a public hearing is held because there's a petition or because it's in the public interest, that doesn't necessarily mean that a feasible and prudent alternative has to be considered, because there's been no determination that there's going to be a significant impact on wetlands or watercourses, if that's the reason for the public hearing. So feasible and prudent alternatives are only required where the activity is likely to have a significant impact. Now, in the course of, if you hold a public hearing because it's in the public interest, or even if you hold it because there's a petition, you may, during the course of that hearing, make a determination that there's likely to be or there is an impact on a significant negative impact on wetlands or watercourses, in which case, at that point in time, you may decide that it's appropriate to look for feasible and prudent alternatives. But generally speaking, feasible and prudent alternatives are only required when there's going to be an impact, a negative impact on wetlands and watercourses. Because, I mean, if you think about it, if an activity has no negative impact, there's no reason to have an alternate plan, because that plan doesn't have a negative impact. So let's go through first. If there's no public hearing, then a decision needs to be made within 65 days of receipt. If there is a public hearing, the public hearing has to, and the date of receipt is the date of the next regularly scheduled meeting of the agency. Every year you file with the town clerk a schedule of your regular meetings. So when an application is filed with staff, the next regularly scheduled meeting becomes the official date of receipt. The agency doesn't have to receive the application formally. It doesn't have to do anything to receive it. It's deemed the date of receipt is the next regular meeting. And that, by the way, is whether that meeting is held or not. For example, if tomorrow night it snows or tomorrow it snows and tomorrow is a designated regularly scheduled meeting, it would still count as the beginning of the 65 days, whether the meeting was held or not, as long as it's a regular meeting, not a special meeting.
Can I just interject though, Pete, because we run into this a lot where across the state, some agencies, some commissions, they insist that they need to take some action to accept an application, and we've tried to convince them from time to time that you don't really have to do that, because as Pete said, it's automatic. It's the next regularly scheduled meeting, but they like to do it. Somehow they feel, I guess, better if they just accept it. I don't really know what you do. I don't remember what you do, but you don't have to have that kind of acceptance kind of portion of your agenda. But I know some commissions just insist that they've always done it and they're going to continue.
Although in the case of a wetlands agency, sometimes while it's not the date of receipt, there's often a first meeting after an application is filed. And that goes to determine whether or not the agency thinks a public hearing needs to be held or not. And you will receive, and you can receive some information from an applicant during that process to make that determination. But it doesn't change. Let's say the first time you meet is a special meeting and the applicant shows up. That's not the date of receipt. It's still going to be the next regularly scheduled meeting after the application was filed. But we do understand that since you have to have information in front of you to determine at least in one case, whether a public hearing should be held, you need to get that information, which is fine.
I have a quick question. We end up getting a lot of applications being filed the day of a regularly scheduled meeting, which means it's hard for us to go through the application material and determine significant activity. I mean, sometimes it's obvious and sometimes it isn't, but when people are filing it on the day of a regularly scheduled meeting, and it seems like that means it's received, I guess, that
Well,
night.
it starts the clock.
Yep. But that means we could still, like, if we don't feel comfortable that we've had enough time to make a determination
No,
for significant activity, we can do that at the next regular scheduled meeting.
absolutely. Yeah, no,
Okay.
it doesn't require that determination to be made at the next regular meeting. So all it means is there's a 65-day period to commence a public hearing if you're going to hold one. So between the day of actual filing, and if that's the same day as the date of receipt, you don't have to make any determination that night. You can wait till your next either special meeting or regular meeting to determine if you think a public hearing needs to be held. But keep in mind, the 65 days starts on that date of receipt, which is the first regular meeting after it's filed. Now, by filing, that means a complete application. Somebody's not going to start the clock if they hand in a piece of paper and it says, I want to do some work in my backyard near the wetlands. That's not an application. It's got to be a complete application. The fee has to be paid, that kind of thing. So it's got to be and the fee may be adjusted if a public hearing gets held for publication and things like that. But at any rate, no, you don't, it doesn't put you under the gun. It just starts that 65-day period to commence. If you don't hold a public hearing, you'll render a decision within 65 days. If you decide later that a public hearing has to be held, it simply has to commence within 65 days after that date of receipt, retroactive to whenever the date of receipt was. Then you have 35 days to hold a public hearing. And then you have 35 days to make a decision on a public hearing, keeping in mind that you can extend any or all of those dates for a maximum period of 65 days. So you can apply, if you need more time to open the hearing, you can ask the applicant, and by the way, the applicant has to consent to any extension. So you can ask the applicant, look, we can't commence our public hearing in time. Will you consent to let us start 30 days later? Now you've used 30 days of your total of 65 days of extensions. So while you're holding the hearing, you have 35 days. You could ask for that 35 days to be extended. But again, depending on how many days, then whatever's left over, you could tag on to the 35 days that you have to make a decision.
And
So,
just for comparison's sake, not to confuse the issue, but that last 35 days to make a decision after you've had your hearing, you have another 35 days to make that decision. That's different than the Planning and Zoning Commission, which has 65 days to make a decision. So I just point that out because you may hear, in some generic presentation, well, it's 65, 35, 65, but for wetlands, that last 65 is actually 35. So still subject to getting extensions, but it does
Correct.
differ in that respect. So we need to keep an eye on the clock.
Right. And generally that's where Maria and Aaron come in. They
Yeah.
will help with those dates and fill you in with respect to what the dates are. But you have to be a little careful about those. Now, if you don't make a date, if you don't satisfy the requirement and the extensions are all used up or extension is not consented to by the applicant and you run out of time, it's not an automatic approval. But in the case of wetlands, the applicant has the ability to go to the commissioner of the Department of Energy and Environmental Protection with the application and ask for approval through DEEP, as opposed to having an automatic approval. It's not an automatic approval. But as a local wetlands agency, we don't want the Department of Environmental or Energy and Environmental Protection making our decisions for us. So we try to make sure that we meet those required deadlines. And there are some in zoning and things, there are some things that get automatically approved, others things that don't. But in case of wetlands, it's unique because there's a state agency that takes over the process if we don't act in time. So that's probably all I had on timelines.
So I'm going to talk a little bit about conflicts, bias, predetermination. Pete, you can interject any thoughts as we go through this. This is substantially similar to the Planning and Zoning Commission guidelines. We start by saying that each one of you has to basically decide for yourself if you have a conflict or not. There's no vote that can be taken to determine it or to kick you off for a night or anything like that. Nor do we as town council, land use council, have any role other than advisory. We're happy to give you our thoughts, and then you have to make the call. So it's not up to anyone else. It's really an individual decision. But keep in mind that if you make the wrong call, then you could be jeopardizing the work of the entire commission. You could spend multiple hours and days and come up with something, and then have a judge later on say that there was a conflict and you shouldn't have participated. And we've had that situation, not too often, but I've had it once a long time ago, and it's very awkward for the person, and you don't want to find yourself charged by an applicant or an applicant's attorney in that manner. So you just have to keep in mind there is a governing statute which is in the outline here. The basic rules are that if you have a personal or financial interest, that's how we define conflicts, basically. And also, you cannot represent someone else before your own commission. So and we've had that situation, not in Madison, but we've had that where someone was some sort of land use professional and engineer or whatever, and decided they could do that. The statute says expressly you cannot represent someone before your own commission. A related issue is whether you can represent someone before another board or commission. So for instance, and this is a real case going back many years ago in a different town, but there was someone who actually was on the wetlands agency, and she had experience. She was some sort of professional engineer, let's say, and she wanted to represent a client before the Planning and Zoning Commission. And I advised that was not a good thing to do. I told her not to do that. She decided on her own to go ahead and do it, and eventually the judge, didn't think that was right. And typically, that you would think most judges would say it's not right because there's a suspicion that the person had undue influence. Keep in mind, when we talk about any of these conflict issues, it's not just the actual impropriety or conflict, but the appearance of conflict, the appearance of impropriety under the law is just as bad. So if it looks to the public as if it's improper, then that could be, that is just as bad if that's indeed the case in the eyes of the law. So we have to be very careful about that. So, we get to, well, all right, personal, financial, that's easy to remember, but how are those things defined? And this is where sometimes it's very easy and sometimes it's not very easy. I mean, there was a very old case from the late 1940s that when we had seminars, people used to say, oh, this was the first case. It was a Planning and Zoning Commission where I think the husband was on the commission and the wife was the applicant. Okay, nowadays we would say, that seems a little obvious, but back then I guess it wasn't. So you need to look at the relationship to the applicants, for instance. and there's all kinds of examples in the outline as to, you know, what might be close, what might not be close. If it's someone that you're in business with in some manner, well, then you probably should recuse yourself and not participate in that. If it's someone you know casually, because you know, Madison is a relatively small town, that may be perfectly fine. So it really is kind of a judgment call as to the nature of the relationship. If it's someone that you see socially frequently, that probably would be grounds to recuse yourself. If it's something that, well, we went to dinner once 3 years ago, that's probably not, in my opinion, that alone would not be enough to recuse yourself. So you want to avoid those personal conflicts or financial conflicts. Sometimes it's best at the beginning of the meeting, if it's borderline and you feel you don't have to say anything, sometimes it's best to say, just want to put on the record that I know Mr. Jones, the applicant here. I know him through, through our church or synagogue or some other organization, but we're not social friends or anything like that. Sometimes it's best to put it on the record, just so there's no suspicion. And sometimes you don't really have to say anything, depending on the particular factual situation. If you do recuse yourself, it is best to state why. So people don't think you're just missing a meeting because of any particular reason, you're sick or whatever. It's best to say why, to avoid the appearance of conflict. And then if that's the case for that matter or for that evening, depending on whatever the situation is, you're best off not even attending, or if you're there for other matters, to basically leave the hearing room at town hall if that's where it is. You can say sit in the back, maybe it's not such a big room, maybe sit outside in the hall. You certainly don't want to sit at the meeting table. You don't want to sit in the front row either. So you need to sit somewhere else is always best. If it's a virtual meeting like this and you were hearing something and you were going to recuse yourself, then I think the best thing is to turn off your video, turn off your mic, and then go have some coffee or something, because that's the equivalent, I think. So that's a little bit about conflicts. We're here to help, and we can give you our thoughts on something like this. Keep in mind, again, it's the appearance of impropriety too, as well as the actual impropriety or the actual conflict. There's more material in the outline, and so I call your attention to that. Predetermination is it's not based on any particular statute, but that's where your words or actions could suggest that you've already made up your mind before the hearing. And most often it would come up through statements that you might have made. If it's an elected board, that can sometimes come into play during an election. But for appointed boards, it most often is, as I say, through comments. Years ago, we used to talk about letters to the editor. Nowadays, we talk about social media and blogs and things of that nature. A lot of Facebook accounts that are unique to a particular town. People write back and forth. The simple rule that we advocate is it's not a good idea to write about any matter that is before your commission. Absolutely do not write anything, or if it's likely to come before the commission. If it's reasonably likely to come before, you should really not participate in any sort of commentary on social media or anywhere, the newspapers or anywhere else, in the supermarket, whatever. You just should not comment, certainly on anything that is before you or is reasonably likely to come before you, because that could be predetermination, and you have to be very careful about that. bias is a different issue, and I think it's more of a if you've shown some particular dislike or preference, I guess, for a particular person, I think more often, well, could be pro or con, dislike or a like of some nature by virtue of the relationship or your comments. But for instance, if you've had some, I'll say, legal dispute with a particular applicant, you don't want to be accused of bias. Well, he or she doesn't like me because we had a lawsuit 3 years ago about something or other. So you have to be very careful about those things. Back on the conflict, another example that comes up is when you live in close proximity to an applicant. You have to be very careful of that also. And again, it's a matter of degree. I mean, what is close proximity? If you live next door to the applicant, you definitely should recuse yourself. But at what point can you keep, do you not have any personal interest? And again, it's really a judgment call. There's no defined, well, it's 3 houses or 30 houses or half a mile. It really depends on the overall situation. That's a very quick summary of conflicts, bias, and predetermination. Anything, Pete, that jumps out that should be added there?
Yeah, no, I mean, other than these concepts are all governed by, or well, they're all governed by the concept of fundamental fairness, as opposed to what some people call due process. Due process is more of a constitutional thing. Fundamental fairness is what courts look for in administrative hearings. And so both the applicant and the public have the right to know that everybody is being treated the same way, and all proceedings are fair, and nobody's being treated differently because of whatever the issue might be. So it's important that as an administrative agency, you recognize that you're dealing with people's land rights, their property rights. And you're balancing, you're doing all kinds of things as an administrative agency. So you have to keep that concept of fundamental fairness in mind when you're doing it.
So I'm going to try to jump through a few topics fairly quickly because I do want to leave sufficient time to sort of get back to the substance of what a wetland agency does, and adverse impacts and upland review and some of those, very direct critical comments. But I'll just go through a few things quickly. There's a little section on rehearing in the materials, and basically the rule that we suggest is that a commission really cannot go back and reverse itself, absent some really new information. But otherwise, if you made a decision, that's it. And the reason is that people will wonder, well, gee, last week they approved this and now they're meeting again to not approve it, or the other way around, perhaps. You turn something down, then someone says, I'd like to have a motion to rehear this, and you then approve it 2 weeks later. Well, what happened in that interim period? It doesn't look good. And for that reason, we say you really can't. Now, if there's, some new information, again, procedurally, I think that still raises some concerns, but it's really not advisable in my opinion. So what you decide the first time is really it. If you come to the end of an evening after a public hearing and you really feel, well, I need more information, then ask for it and continue it. But once you make a decision, basically that's it. Public inspection, any documents that are submitted are part of the public record available for inspection. And by the way, if you receive emails or even texts individually that are not sent to everybody, that are not sent to, say, to Maria at the office, then really what you should do is forward them to her so they can be put into the public record. So everybody can see them, everybody on the commission, everybody on the public. And I don't know if you put everything on the website now, but if that happens, then everybody in the world can see them too. But, you know, we don't encourage the public to write individuals like that. They should send something, you know, to, in my opinion, to the office, be put into the file, distributed to all the members of the agency. You can all see it. Then it'll be in the file for public inspection too. But if you
And
get,
I'm sorry, didn't mean to interrupt, but in that vein, the members of the agency should not be interacting with each other
right,
outside of the public hearing. It's the public business should be done in public. So individual members of the agency should not communicate. You can communicate with Aaron if there's a, you know, if there's a question or something of that nature, or Maria. But in terms of talking about an application, you should not be communicating except during the public hearing.
yeah, two different issues though, but both important. If you get something from an outside person, so I went through that, what you should do with those kinds of emails, make sure everybody sees them, they go into the file. Between yourselves, as Pete is getting at, that would be, you know, you may be having an illegal meeting under freedom of information if you communicate back and forth. Now, that doesn't mean administrative things. You know, Maria tells you, you know, you're meeting with land use council at 6 o'clock on such and such a night. I mean, that, then you write back and say, well, I'll be 10 minutes late. That stuff's okay. That's administrative, but not on any substantive matter. Save it for the public meeting. Otherwise, you could be having an illegal meeting under the FOIA law, which is state law. And we're back to fundamental fairness, which keeps coming up. You'll hear, and the public should be able to hear what your comments are, and they won't if you're doing it, you know, back and forth through email. Quickly on site visits, these are public meetings. So if you're going as a group, it has to be noticed. They're public meetings. The public can attend. And you can't, if the owner says, well, it's okay for the agency, but I don't want any public. Well, that's a problem, because they are public meetings. And if the applicant homeowner says that to you, then we say, well, then you got to cancel that site visit, which is usually not good for the applicant. So the public's allowed, they're not allowed to talk. We discourage all conversation during these site visits, except something which, you know, might help you get your bearings, like, well, that's the property line, here's the wetlands, etc. Other than that, save your conversation until the public meeting. And the public also should not be speaking. So that's the quick overview of site visits. The record is what when we talk about the record, I think you all know this, we're talking about all of the documents that go into the file that are given to you, the application, all the reports, letters, things of that nature, plus the transcript that constitutes the record. If there's an appeal from your decision, it goes to the Superior Court, and that's in New Haven. Certain land use matters go to the land use docket in Hartford, but not all. So, but they go to New Haven. We've had some experience recently with Judge Wilson, and that's where we go. And she will get the record that'll be prepared. We'll write briefs. She'll make a decision. And that's quickly. I'm going over a lot of things pretty quickly, but
Well, and I just was wondering, did everybody get a copy of her recent decision on the ledges that she, there was an appeal from your approval? And I think you probably got it, but at any rate, Judge Wilson, this is a month ago, maybe a little longer, but she sustained your decision. She determined that the
upheld
who
your
is it?
decision. That means
who is a neighbor did not meet their burden, and that's it. It's a well-written decision, so kind of gives you a little bit of insight into the kind of stuff that most judges are looking for when they're reviewing the record and what's important to them and what isn't. So, and if anybody needs a copy of that, let us know and we'll send it to you, or I think Erin has a copy of it. She could provide it.
Yeah, Pete, we sent both Judge O'Hanlon's on Cottage Road and Judge Wilson's for the ledges.
Good,
So the commission did have an opportunity to read those.
good.
Yeah, and they were good. It was instructive.
Yes, that's,
Yeah,
gives
I
you an
was just
idea
gonna
of what, yeah, so.
just to highlight that, if you haven't had a chance to read it, it really is good to read it and kind of see how a judge sorts this all out and thinks it through. And she wrote a very good, thorough decision. I mean, a lot of decisions are like that, but I think it's illustrative of what the law is requiring. So if you get a chance, go through it. Pete, I was going to ask you, it's in the outline, but I was going to ask you about a situation here where an agency member intends to use his or her own expertise or personal knowledge of a particular site as a basis for a decision. Because we were talking about that a couple days ago.
Yep. Well, two things about that. It's not prohibited as long as during the course of the public hearing, if one of you has expertise about a certain matter, that would, that could go to challenge, for example, an expert witness. Excuse me, pardon me. It's not improper for you as a member of the agency to have that opinion, but it should be voiced during the course of the public hearing. It shouldn't be brought up for the first time during deliberations. I had a case like that in Fairfield, and personally, and it's unfair thing to do because neither party has an opportunity to question that. Remember, when a court is, and you saw these words in the decisions we just referenced, the court is looking at substantial evidence. And substantial evidence means expert testimony, basically. Substantial evidence doesn't mean, is not a qualitative sort of determination. You could have 5 experts versus 2 experts. You can determine as an agency that the 2 experts gave you better information, you thought they were more credible, whatever. So substantial evidence is simply evidence that expert testimony that supports your decision. You don't have to believe it. However, if there's no expert testimony, let's just hypothetically, you get an applicant who comes in and they have an engineer and they have a soil scientist and they're presenting their situation, and it comes time for the public, and maybe some members of the public speak against the application and think it's a bad idea, and in their opinion, it'll have an adverse impact on wetlands and watercourses. But no engineers or wetland scientists or anybody else are testifying beyond what the applicant experts said. There is case law in Connecticut that says then you have no basis to deny that application in the absence of that expert testimony. So that's sometimes when there's a controversial or a significant application, that's sometimes why the agency will get a peer reviewer and take a look at what the applicant is claiming to be true. In the absence of some other evidence, the peer reviewer, who will be an expert, would be able to provide that kind of testimony. But in the absence of that, your decision has to be supported by substantial evidence. So if there is no substantial evidence, and there is on the other side, then you really cannot make a decision to deny that application. That's why if anybody has expertise, they need to, and can substantiate that, they need to make that known during the public hearing. So, anyway, it's kind of tough, but we see that happen sometimes where, it looks to the agency like, wow, this is going to have an adverse impact, or these waters are going to flow over here, but there's been no supporting expert testimony to that fact. And there's been contrary expert testimony. Then, if you deny it based on your perception and it's not supported by expert testimony, a judge is likely to reverse that. So be careful about making sure that your decisions, especially public hearing matters, are that there is expert testimony in the record to support whatever finding you decide to make.
Ex parte communications, speaking to somebody on your own outside the public hearing, cannot do that at all. It seems obvious, but it does happen occasionally that sometimes we even get asked, can I call the applicant and ask a couple questions? No, you can't do that. Everything has to be done at the meeting table in public. So no communications with anybody, consultants, applicants, etc.
Unless the public hearing's still open.
Well, at the
Then
public
you can
hearing,
ask it
yeah.
during the public hearing.
During the public hearing, yeah.
Right.
No, I'm saying outside the public hearing,
Right.
you can't do any of that. Yeah, and then of course, once the public hearing is closed, then you can't do it at the public hearing either, because it's closed. If it's closed, it's closed. And that's kind of the last quick topic here before we get to jurisdictional authority and limitations, which I'll turn it back to Pete. But once the hearing is closed, with some very limited exceptions that I'm not even going to get into, because I think it's just safer to say if it's closed, it's closed, and you really shouldn't get any other material. And I just want to leave it like that, because it's risky if you get anything, or it could be a violation. Obviously, because if you get something from an applicant or a neighbor, well, then the other side doesn't have time to respond to it. So get everything in, obviously, before the hearing is closed, and then you go to your deliberation session. You can hear from an attorney, you can hear from certain town officials on a limited basis. So we'll leave that for the moment. I'll just say on executive sessions, just very quickly, that they're probably rare with a wetlands agency, except if you have a pending case, pending in court. This would be the most likely executive session that I think you will have. Then we can go into an executive session outside the public view and discuss the case. You can't take any action, you can't vote in executive sessions, but you can have that kind of discussion. It's enumerated in the FOIA statute when you can go into executive session, and there are other grounds, but I think for land use agencies that's usually the almost the only one with any degree of frequency. So that covers that. I'll just say something. Well, let's get on with the next topic. Really dealing with some of the jurisdictional issues for a wetlands agency, and I'll let Pete walk you through this and some of the main cases from the outline.
Yeah, there have actually been, we cited a couple of them in the outline, but there have been dozens of cases that sort of set the parameters of what a wetland agency is allowed to consider. First thing the agency needs to be aware of is that it's a balancing test, that you're balancing the impact on wetlands and watercourses against the concept that people have the right to use and develop their property. So it's a balancing test. It's not, wetland regulation is not an outright prohibition against any activity. So it's any activity in theory could be approved if the condition, subject to conditions or whatever. That doesn't mean that every activity has to be approved. It just means that there's not an automatic, shouldn't go into a hearing with the concept that we should be denying any activity within a wetland or watercourse. It's that balancing test that needs to be employed. And so and remember, and your jurisdiction is also technically limited to wetlands and watercourses, impacts to wetlands and watercourses. You have an upland review area, which, by the way, activity within that area is subject to review. But any activity, whether it's in an upland review area or beyond that, can be subject to your jurisdiction if it can be shown that it will have an impact on watercourses and wetlands. It's your jurisdiction doesn't stop either at the edge of the wetland or watercourse or at the edge of the upland review area. It extends beyond that if it can be shown and proven that there's an impact on wetlands and watercourses as a result of that activity. So you can review those types of things as well. A lot of kind of a recurring little almost pithy thing saying that is in a lot of these cases is that inland wetland agencies are not little, quote unquote, little environmental protection agencies. It's a phrase that you see a lot in these cases. All that means is that you're limiting your review to impacts on wetlands and watercourses, not, for example, air pollution, or not, if there's no impact on wetlands or watercourses, there could be activity that you might think is detrimental to the environment as a whole, but doesn't affect a wetland or watercourse. That's typically not within your jurisdiction. So there's got to be a direct impact on wetlands and watercourses. The impact also has to be specific. It has to be identifiable. It can't be, a probability or it can't be hypothetical.
Speculative.
Pardon?
Speculative.
Speculative. There's got to be some scientific or other basis for establishing that there is in fact an impact, not that there could be an impact. So, anyway, that's, and it's not easy to do that because you are the wetland agency. So your sense is that we got to protect wetlands and watercourses, and you do. But you don't do it in a vacuum. And you look for, in fact, what the impacts to wetland and watercourses are going to be. Areas outside of the wetland itself, if there is an impact, if you're looking at activity in the upland review area, for example, then you're limited to looking at the impact of that activity on the wetlands and watercourse, not on, for example, the animal life that might exist in the wetland or watercourse, if the activity is outside of the wetland and watercourse. So generally but if it's within the your activity within a wetland or watercourse, then you are going to look at that impact on spotted salamanders or frogs or whatever the wildlife might be, if the activity is within a wetland or watercourse. And again, remember, just because it's in the wetland or watercourse doesn't mean that it's prohibited, but it is regulated. And for example, there's a case we're working on right now in another town where the only access to a property is across an old road that goes through a wetland. It might even go through a vernal pool. That hasn't been established yet, one way or the other, but it passes right through this. And so if the agency decides there's nothing that we can approve, there's no feasible and prudent alternative. I mean, somebody could build $1 million bridge, but that's not that's not a prudent alternative typically for one lot, because cost does enter into that analysis. But if the agency decides there's no way, there's nothing that can be done to give this person access, then they may have the right to claim that their property has been taken. And it doesn't happen a lot, but it could happen where a person basically brings an action against the agency in the town for compensation, saying you've deprived me of any reasonable use of my property. You've given me no alternatives. There are no alternatives that are either feasible or that are feasible and prudent. And therefore, I have this lot here, can't use it. You got to buy it. So, and that happens, on rare occasions. But it's something to keep in mind. If it's determined that there's no possible way to allow someone to do some activity in a wetland, you may be looking at a taking issue. So, you use as much, and that can happen. Every activity is not subject to approval. Some activities are not going to be approved because of the impact on wetlands and water courses, and the impact simply outweighs the property rights that someone has. So that's kind of goes into the balancing test. Let's see, what else I want to talk about here.
Can I ask a quick question on that?
Sure.
So sometimes there's been two since I've been on the commission where someone has had a piece of property that they acquired decades ago. And in one instance, it hadn't been approved as a building lot. And they were proposing to put a house 3 feet from the wetland. Like it was, and we denied it. But it wasn't approved as a building lot at the time, whereas we had this more recent one where it was part of a subdivision from decades ago. Not ideal, still close to a wetland, 20 feet now. And we did end up approving that with lots of conditions. But is there, does it have to be approved as a building lot in order for it to be a taking? And if it's not approved as a building lot, is that not a taking? Are those different?
Yeah, it's not necessary. It's the value of the property that determines it. Any property can be taken, whether it's a building lot or not. But the value of the property would be substantially less if it's not a building lot, for example. And by building lot, I don't know, Gail, if you're talking about an approved building lot by planning and zoning, or remember, whether a lot is approved by planning and zoning or not, it's still subject to the same inland wetland regulations as any other lot. You don't get a pass because planning and zoning approved your lot. Now, nowadays, before a subdivision is approved, you are supposed to see an application submitted for a subdivision and write a report to the Planning and Zoning Commission ahead of time before it gets. Now, that doesn't mean you're reviewing regulated activity, but you're saying, there's wetlands over here. This lot is, may not be able to be developed. It's a report you write. But in answer to your question, the taking argument can be made whether it's an approved lot or not, but it really would be fact dependent in a case like that. So, but it's not determinative just because the lot had been part of an approved subdivision or predated subdivision or something.
I think the other, oh, I'm sorry, Ira.
Oh, go ahead,
Go ahead,
Aaron, go ahead. No, you go, please.
My other question, I think, with that, picking up on Kayla's comments, that's where, and the commission is starting to do this more and more, is the third party experts. So in order to explore that possibility that there are not prudent and feasible alternatives, that's when they're taking advantage of that opportunity now to hire their own experts. Because one of the questions with one of these particular applications, we didn't have any expert testimony on, anything to counter what the applicant said, even if there were concerns. So there wasn't that peer review that the commission could lean on for expertise, for guidance to help kind of determine if there were prudent and feasible alternatives, which I think the applicant explored, but they just didn't have any expert on their side. And I think we're starting to see more and more the value of that in some of these more in-depth applications, because some of them they're getting a little more and more complicated as we go. You're getting shorter on land or more extensive development, things like that.
You should definitely take advantage of that, either regulation or ordinance. I'm not sure, I don't recall what you have, but to allow you to hire that peer review person and pass on the cost. I mean, I would use it quite liberally, as needed, of course, but take advantage of it, because it's very important that you have somebody reviewing it for you.
Yes. And does that only, so we've only been using it for applications deemed significant activities and that have public hearings, but can we use that for regular applications as well? Or is it only for significant activities?
Well, typically it would only be used when there's a public hearing, when there's significant activity, because if there's not,
right,
there's probably no real reason to have a peer reviewer. I mean, if you've already made the determination that this activity is not likely to have any negative impact on wetlands or watercourses, you don't necessarily need to have that kind of, but if you're thinking about hiring a peer reviewer, then that to me means you should set it down for a public hearing.
Yeah, the two go kind of hand in hand. And I'll just back on the question of, expert, there shouldn't be speculation or speculative answers. I'm sure you look at the reports and read the testimony that you receive carefully, because, the language that's used in a report or in oral testimony is very important. There's a difference between someone saying, yeah, it's possible that this could happen here in this application that would be adverse. That's one thing, versus someone saying, yes, in my experience, I've seen this before, and there's a high degree of probability that I think this will create some sort of impact, adverse impact. So, one sounds like a little more hypothetical, speculative. The other sounds a little more definitive. And that's something to note as you think about it and deliberate.
And keep in mind, to side note completely, the wetland agency is not, if you get an 8-30G application in your town, you review that the same way as you would anything else. That 830G affordable housing application, the burden shifts only for the Planning and Zoning Commission. So.
And lastly, we haven't talked about environmental intervention under 22A19, but I'm going to guess that you get a number of those where someone submits a petition and you have some basic familiarity with the law, and it's a powerful tool that's created for folks seeking to raise environmental issues. They don't have to be adjacent, they don't have to be aggrieved, they could be anybody, even from a different town. Submitting a petition. It has to be a verified petition. They have to state sufficient facts, they have to back it up with evidence, and it does require certain specific findings by your commission. It presents, I'll just say, a complication when it becomes time to have, if there's an appeal, because that environmental intervener very often is also a party to any appeal, and has a quote seat at the table if we are trying to negotiate any settlement or any compromise. So, but that's the law in Connecticut, and these petitions can be brought before a variety of agencies. It certainly seems directly relevant to what you do as the Wetlands and Watercourse Agency. So that's a very brief discussion of that. And if you have questions, we can answer them. Or we can
Ira?
try to answer them. Yeah, Aaron.
When, so the intervener, I mean, we've had a couple of them, at least in my experience with the commission. And they're usually dropped when the hearing opens, somebody brings it, at the opening of the hearing
Yeah,
and delivers it during public. You don't really get a lot of forewarning that there's going to be one. Is there ever a point during the hearing, like, can someone give it at the 11th hour, an intervention as
Yes.
well? Or does it, I've never experienced it, but I'm just thinking that, like, there isn't like a set protocol that it has to be upon opening the hearing or anything like that.
No, it doesn't, but it has to be during the public hearing. And if an intervener submits the verified petition too late in the process, they may not have the opportunity to present. They have to establish their claims by sufficient evidence, substantial evidence as well. So, if somebody walks up as the public hearing is closing and says, I want to be an intervener, well, their verified complaint might allege facts, but they haven't proven anything. So
yeah, and then you're faced though with using that example where literally they walk up, before you're about to close the public hearing, and suppose it is a properly prepared verified pleading, and they say, okay, well, sorry, but I just heard about it or just hired an expert and he or she is not available tonight, but I'd like to come back in a couple of weeks. And so what do you do at that point? Those are the kind of things that we face. If there still is time, I probably, as much as as you may not want to, in that situation, if it seemed, well, I probably would say, well, why didn't you come a little earlier? But we'll have to continue it to give you a chance. So we're back in next week or 2 weeks or whatever. So it could be problematic. Some
Okay.
people take advantage of this. I've sat at meetings where, there's an environmental intervener with a verified petition, and it's being done very sincerely and professionally. And then I once had a guy, I was the town attorney, and he comes up to me and he has like a piece of paper, like, he says, waving a piece of paper. He says, I just wrote this out. Think this looks good like this. Can I intervene tonight like this? It was like handwritten scribble, because he heard the other guy saying something. Well, it wasn't verified, but
yeah, it's got to be verified. And it's got to allege facts. It's got to allege sufficient.
no. But that actually happened. He just threw something together because he thought, hey, here's a way I could, say something and get a seat at the table. So that doesn't happen too often. But I think you're right, Aaron, that it's nice when they come in earlier, and a lot of professionals in this business will do that earlier to alert you that they're serious, they have serious concerns, and they're going to, present their evidence. But very often it's just at the beginning, towards the beginning of the meeting.
Okay. Thanks.
I think we've covered most of the topics that we wanted to cover.
We attached, you didn't need it probably, but we attached a copy of your own regulations and then the relevant state statutes that deal with inland wetlands and watercourses. There's obviously there is a separate section for tidal wetlands. That tidal wetlands are under the jurisdiction of the state. And so we don't review tidal wetland activity. That statute was there, just wanted to include it in the package so you had access to it easily if you needed it at any time. And obviously, Ira and I are available if there are questions come up, during the course of a public hearing or after, again, as Ira said, it's best to have your questions asked and answered during the public hearing, not after. But but, we're here for, to try to help you.
Pete, can I ask you just for some guidance as far as the public hearing process? We've kind of gone through this, but I've had some commissions stumble on the proper way to move forward in, as far as the applicant presenting, and then when should the agency, or when there's an intervener, when they should speak up, or just general opposition. We've had, I guess, and maybe this is a shoreline thing. I don't know. But I've had this in other towns where I've worked, where the commission would ask for, anyone with a question may speak up, anyone speaking for, then they'll have an opportunity, or anyone speaking against. Can you give, just so that we kind of hear from you, what's the best way to move the hearing along? Because sometimes you get opposition who may not, even if it is an interview, but they'll be pushing that they want to have the last word. And it kind of tends to go on ad nauseum. So I think we would benefit from that.
For starters, I know you asked Pete, but the last word should be the applicant. But go ahead, Pete, you can.
Yeah. Yes, the applicant always gets the last word. The best order of things in my mind is the applicant does his or her presentation in front of the agency. The agency then asks whatever questions they have of the applicant. Just the members of the agency ask questions. Then next would come a staff report. If staff has prepared a report, whatever comments staff has. Then if there are any
Interveners.
members of like the town engineer or anybody has a comment, and the peer reviewers would follow that. Then the intervener would have a chance to put on their case, and then the general public. And then the applicant would have the final word to respond to any of that stuff. Now, it doesn't always happen where it all ends that quickly, because new information may come in and it has to be reviewed. But if you keep that sort of basic order, applicant, agency, staff, intervener, public, and then applicant again at the end. That's the best way to do it. And you should never have a situation where members of the public are shooting questions in the middle of a presentation, whether it's by the applicant or a peer reviewer, or even while the agency is asking questions. The public's portion of the public hearing should be defined. This is when you get to make your comments. You can send in comments in writing anytime you want, but during the course of the hearing, this is the order we're going to follow. It makes the most sense, and I think it seems to work well in other towns that do it that way.
I'll just add, I'm not a big fan of, all those in support speak at one time, and all those against speak at another time, or first or second. I think that sort of isolates. What if there's just one person that's against it? Or I just think it should be you can have a sign-up sheet and do it in some orderly way, but I don't think it's good to say, all right, everybody in support, you sit over here, you speak first, and then I don't think that's a good idea.
No, I agree.
I agree with everything Pete said. In most complicated applications, though, there's a little back and forth. Then at some point, the applicant will say, "Well, I just heard the interveners expert for the first time, and I need some time now to respond, to have my engineer respond to the 22A19 engineer, whom I heard for the first time tonight, just now." Okay, so that's fine. So you come back, and then there's a back and forth. Well, then the 22A19 person says, "Well, I want my engineer to respond to that," and then the public says, "Well, this is all new information, so we need a second chance to comment," and that's where it could get a little hectic. But you try to encourage this exchange of reports to be done in advance of the meeting. All right, I want all reports submitted back and forth to the commission and to the other parties, 3 days before the hearing. So everyone has a chance to read it, as opposed to just at the meeting.
Yeah, and
it can get tricky.
so that definitely comes up where we're getting new information at public hearings, and it's incredibly frustrating.
Yeah.
But the other question I have is, so sometimes what's been happening are members from the public are asking the applicant or the expert or somebody a direct question, and then there's that back and forth, and that gets messy, and but you want people to be able to ask questions, but having this back and forth of a member of the public with the applicant or the expert or whatever, I think it's messy sometimes.
Well, I was going to say, Ira, that if members of the public, first of all, the purpose of public participation really is more comment than questions. However, I recognize that, some member of the public may have a good question. They should ask during their comment, they should raise that question to the chair and and then the chair can ask that question of the applicant when the chair is asking questions, later. But it shouldn't be a back and forth between a member of the public and someone who's up at the podium, an expert or whoever, because it does get unruly. And also, when that happens, unfortunately, people don't identify themselves every time they speak. They get up and they say, my name is Joe Smith. I live, here. And then they talk. And then there's a back and forth. There's no way for a transcriber to know who's saying what at that point in time when you get that kind of back and forth. When a commissioner, when an agency member is making the comment, it's a little bit easier because there's a video typically of that. They can look at it, but it's so and it makes the meeting unruly as well. It just becomes out of control. So it should be comments. If a member of the public has a question, it should come through the chair, and the chair will ask the question, at the appropriate time.
Or another way to handle it, a variation of that is accumulate the questions and then have the engineer, let's say for the applicant, come back up at some point towards the end and say, all right, I heard 6 questions. Let me try to answer them now all at once. So not the back and forth, up and down. And I think most professionals would keep notes. So if they heard, the member of the public can say, well, I'd like to ask the consultant, Mr. Smith, through you, the chair, or I'd like to get this information. And so usually the good engineers and lawyers will keep track of that and then address it later. Or you can ask them to keep track of everything. And we're going to ask you at the end to address all the miscellaneous questions that have come up. So just another way to keep some sort of order. Yeah, you don't want people jumping up and down and, back and forth from the back of the room and all that.
And by the way, you can limit the amount of time that some member of the public has. Now, that's a little tricky because you can't say, you have 2 minutes. That's all you have is 2 minutes. But what you can do is if a member of the public starts to repeat and says the same thing over or talks about things that are irrelevant, you as the chair can say, if you have something new, that's great. Otherwise, we have a lot of people here tonight that need to speak. Limit your comments to what's germane to our agency. And, it's okay to keep control of the meeting like that. And, I'm not a big fan. I know Ira isn't either, of saying everybody limit your comments to 3 minutes, because that's not always possible. But it is fair to say, interrupt somebody and say, we've heard this, and when you come up, try to have something new. If it's been said 5 times by your neighbors, we don't have to hear it. It doesn't matter if we hear it 5 or 6 times. The message has gotten through.
You really cannot limit the applicant. You cannot limit the
applicant definitely can.
Yeah, definitely not. There are a lot of commissions that do put time limits on general public comments just to keep some sort of order. And, I've so you do see that a lot, but definitely not on the applicant or the interveners or anybody who would be a party to the proceeding. Anything else?
I have one more, not to keep you too long, but I've had some commissioners, and I think we're lucky to have several commissioners on the agency who are professionals in the field. And my question goes to site walks, because I don't have the answer, and I'd like to guide everybody a little bit. What level of investigative, if any, can inspection can the commission members do during site walks? What specifically are we permitted to do? I mean, we have soil scientists. Can they be augering, taking a soil sample? Can we be taking, or nets, or looking at wildlife? Like, what level of investigation can happen during a site walk safely, I guess?
Well, observation, certainly, that's why you're doing it. So if somebody sees something and they want to raise it during the public hearing, that's certainly fair. I've never heard of, any
Okay.
other scientific tests or samples being taken during a site walk. I don't think that's intended to be the opportunity for that.
Well,
Yeah,
so I will just say, I
Well,
usually bring a net to see what's in any wetland. I don't keep anything, but if there's water and it's a time of year where there might be something living, tadpoles or fairy shrimp or whatever, I will bring a net and just see what's in there. So it's
And then report
observational.
that at the hearing.
Right. It's yes. If there's
I think
there's
you have to,
anything,
you have to
Yeah.
report that, so it's part of the record as to what you did, and
yes.
then
Yeah.
somebody can
So-
respond.
And you really need to make sure the property owner doesn't have a problem with that. I mean, they can let you onto the property, but a net's not disturbing anything, I understand. But, to the extent, certainly a soil sample or something, that it's not implicit in the permission to be on the property that you can disrupt it. Now, I don't think a net does that. I think if you take a sample of the water through the net and see what living things are in there, that's, but then again, if that's going to become part of your deliberation, you need to make sure that all parties are aware of that during the hearing. You couldn't take that information after the public hearing and say, well, nobody brought this up, but I saw all these, tadpoles in my net, and but nobody said anything about tadpoles, but they're there. So make sure that information is out there for everybody to see before the close of the public hearing.
That makes sense.
I
But as
mean,
far as
I'm just going to say this, I wouldn't encourage a lot of that. So I think it's not the intent of a site walk, but I'm open to hearing about it. But as Pete says, at a minimum, you need to bring that up at the public hearing.
Remember, you guys are not the applicant, nor are you the opposition. You're there to gather the evidence that's provided to you, and make a determination based on that evidence. So, I understand, Keola, that you're talking about having as much information as you can possibly have, but, like any fact finder, you don't always get all the facts. You get what is presented to you by applicants and opponents, and other experts. And your job is to make your decision based on that. Again, if you're basing anything on your own personal observation or knowledge, you need to make that known to all parties during the public hearing. So they have a chance to either test what you found or, know at least what it is you might be basing your decision on. It's never a game of gotcha. It's always a game of fairness. And, everybody has a chance to know everything about the application that's out there that they can know, that everybody knows. Everybody needs to be aware of the same facts and circumstances so that the decision can be made. And everybody has a chance to respond or not.
Right. And I know we're talking about public hearings, but we have gone on site walks that aren't public hearings. And that in that case, there often aren't necessarily wetland scientists from either side, presenting information. So we did a site walk to it was going to be a subdivision with some houses, and it was just to look at the subdivision and figure out, did that make sense? And there was a wetland, and so I netted, and there were tadpoles, and it looks like a wetland that wouldn't have tadpoles. And I mentioned it. I obviously showed the applicant who was there. I was very upfront about it. But in that case, we weren't going to get more information, right? It was just going to be.
Yeah. And in that case, wouldn't you then set it down for a public hearing? Because it may have an impact on wetlands or watercourses. Remember, the two kind of go hand in hand. If an activity may have an impact, hold a public hearing. If it's not, then you're not going to have a public hearing, and there's not a lot of reason to investigate it except to determine whether a public hearing should be held. But if you've already made a determination that there's no, significant impact, likely significant impact, then, you're sort of your decision. I mean, look, can you do that? I suppose if but then maybe it's time to say, well, we should hold a public hearing.
So if I'm following that correctly, Pete, so the commission often will, and I think sometimes just because maybe people aren't as familiar with reading site plans or things like that, they may visit, schedule a site walk just to kind of familiarize themselves with exactly what the project kind of looks like, right? Like, what's the topography out there? How far away really is this? What are the tree coverage, things like that. So I think that's where KLO is going, where we've had quite a number of site walks over the last year. A lot of those were not significant activities, but really just kind of to help the commission familiarize themselves with the project and, just to kind of relate the site plan to actual layout of the site. So
I don't think that's
are you saying there's
No.
a difference between like one that is a significant activity and the extent of, whether it's a scooping? I think the augering is, I do kind of think that's a little bit different than, a net scoop in a wetland area.
Yeah. No, I don't think there's any prohibition against doing that kind of thing. I just, and by the way, the fact that a public hearing is not held doesn't mean that the commission can't place conditions on a permit if it grants it, and it may do that even if there's not a significant impact. You can still, place certain conditions on something like, look, there are, look like there are tadpoles over here, so put some hay bales up or whatever. I mean, what, I'm just making up conditions, but outside of the scope of the public hearing. So I don't think that it's
Okay.
necessarily a problem to go out there if there's not a public hearing, to familiarize yourself and maybe look at certain things and say, hey, maybe we should have a condition about, doing this and this on this permit. It just means we
Okay.
haven't held a public hearing. So,
Or even coming back to the meeting and saying, well, based on the site walk, what I saw, I think now, I didn't realize this at the last meeting, but at this point think this could be, could have an impact
Sure.
on the wetland
Yeah.
and would
Yeah.
recommend to the commission that this be a significant activity.
Yes, absolutely.
And then that can be considered. Okay.
Then
So
they can hold a
sometimes
pub-
if it's
That makes
on
sense.
for a receipt, the commission could do a site walk to better familiarize, look at it before making the decision I know you lose time in doing that,
Right.
to get your experts on board and to hold a public hearing, but that is an option to kind of look at the site and then make a determination if you think it's a significant activity.
Correct. And you do have the
Okay.
additional time if needed that the applicant will undoubtedly
Okay.
give you, because if they don't, if you need more time to do something and the applicant won't agree to it, well, the response
It
is going to
gets
be
denied, yeah.
denied.
Yeah.
Denied. We didn't have
Okay.
enough time. So,
Okay.
Okay. I got it. Thank you.
All right. So if you need us, give us a call.
yeah,
Thank you. This is very helpful.
Good.
good. Glad. All right.
Yes,
night.
thank
Well,
you.
thank-
And you're
thank-
okay if we share that with the rest of the commissioners who weren't here?
Absolutely. This
Okay.
is all public information. Yep.
Thank you.
Good.
Yep.
Thank you both. Have a great night.
Okay.
Okay.
Thank you all.
Good
Yeah.
night,